Hi, I'm estate planning attorney Michael Redden. Today I want to talk to you about whether or not you can make a handwritten change to your will, or whether or not you have to go back and have your lawyer do it formally. And before we get into that, if you have any further questions about this after the video, or if you find you want to plan with me, you can set up a meeting with me either in person or over the phone by going to setestatemeeting.com. That's setestatemeeting.com. Now, this is a question I get a lot. What if I just have a little bitty change? It's just one thing I want to change to my will. I mean, do I really have to go back to my lawyer, go through that whole thing of getting a new will, having witnesses and things like that to make it formal, or can I just write it in there? And let me tell you, this is an interesting question. Now, I can give you the Minnesota answer, and there's some concerns you need to have for other states too, because just because you got your will done in Minnesota, if you move out of state or something like that, you may not rush to get your will updated or something else, and it kind of has some consequences. Okay? Now, in Minnesota, if you make a handwritten change to your will, the court is just going to ignore it. Remember, wills are meant to be probated, so they're going to be interpreted by a probate court. And if you got a handwritten change on there, the court's just going to ignore it, and they're going to go with what was typewritten and properly witnessed when the will was made. Now, this is not true for every state, okay? Some states handle this differently. There are some states where if you go out there and you write any kind of handwritten change on that will, it's going to void it. That means they're going to pretend like you just revoked the entire will. There's now a question whether or not it's valid. We're just going to throw it out, okay? And that's important. If you get it done in Minnesota, you leave, you retire, and you take 4, 5, 10 years to get your will updated, something happens to you, maybe that court's going to throw that will out, because your will has to be probated where you were, where you lived when you died, not where you go travel, not where you go and visit. If you're living there in that state, that's where the probate's going to happen, and you have to go by their laws on that in a lot of occasions. So making the handwritten change to your will, that's going to potentially put your will in jeopardy, and in Minnesota, that's not even going to be recognized. So if you want to make those changes to your will, give your lawyer a call. Unfortunately, you're going to have to go through Minnesota making a change, either redoing the whole will, or making a small change called a codicil. But both of those things you're going to have to sign it in front of 2 witnesses again, just like when you did the first will. And that's the only way those changes can be made. So at least for Minnesota, don't write handwritten changes on your will. It won't invalidate the will for this state, but we're not going to honor those changes. And again, if you have further questions about this, or you'd like to plan with me, you can set up a meeting for free on the phone or in person by going to setestatemeeting.com.